Good morning, ma'am.
Good morning.
You were charged with driving while intoxicated. You were facing up to a year in jail and or a $4,000 fine because of the high blow. You have worked out an agreement where they're offering you 3 days in jail with credit for the 1 day that you've done. You need to understand that you're entering into a very important agreement today where this DWI will go on your record. It's going to be there for the rest of your life. This is serious business because if you ever get pulled over again and you have some kind of funky smell, whether it's alcohol, whether it's dope, anything, it's probably not going to go well for you because they're going to look that you have a prior DWI. And do you understand?
Yes.
So I would never, even if you've had a sip of alcohol, get into a car because you're begging for trouble. We all make mistakes, but when you continue to make mistakes that you endanger other people's lives, the sentences get longer. You know, the costs go skyrocketing. You understand?
Yes, I do.
So there is a $6,000 surcharge that would tack on because this is a 0.15. I'm going to waive it for you today. If you come back with another DWI, get ready. Because
he isn't giving a suggestion, he's warning them about what's coming. And based on how he says it, the outcome is almost guaranteed. Time in custody and a big financial hit. He also uses the Uber example to make a point. Judges often like to remind people that spending a small amount now can save them from losing a lot more. Later,
it gets a whole lot worse. Not only that, from now on, it's a minimum of 90 days in jail. You pick up another one. Do you understand?
Yes.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, this will go on your record. You can never take it off. Is this what you want to do?
I understand.
Okay, how do you plead to the offense, man? Guilty or not guilty? I'm going to find you guilty. Sentence you to 3. Is it true or untrue that you had a 0.15 or above?
It's probably true.
Okay, true enhancement. Okay, I'll send you 3 days in jail, credit for the 1 day that you've done. I'm going to suspend your license for 90 days. Do not drive until you get a license. I'm going to waive your supervisory fee, but be careful. You come back on another one, it's going to cost you an arm and a leg. Do you understand? For $50, an Uber, take you wherever you want to go. $50.
That's what I'm doing now.
Good. Good luck to you.
Yeah, and I do have a question. There is something weird with her license. We're unable to get a status of her license.
Yes, absolutely.
I think state did just a few minutes ago too, and they couldn't get anything.
So
I don't know. Gaskin is the last name. I don't know. You know, that's something you may just have to call DPS to figure out. You have your license number, correct?
yes.
This is the number, Deputy Brand, that's the number to the Driver's License Division of DPS. Call them right when the phone line's open at 7 and you'll get through. Don't try at 7:20, 1 o'clock, you'll never get through because they're so busy. But if you call right at 7 o'clock in the morning, you'll be able to speak to someone and they can tell you what the problem is.
Judge, even our it won't return to anything. I'm not sure.
There's something's wrong. I don't know. I mean, we only get access to be able to put a number in and it'll spit out information as to the status of the license, why it is. I don't know. Maybe it's got to be an incorrect number or something. Maybe then you can hear it straight from them. You know, that's what I would do.
All right, and I do have one more question here. I'm sorry. If we find that her license was previously suspended for 90 days, would you be willing to give her credit for that 90-day suspension?
Yes, but you have to give them the dates and everything.
Gotcha. Yes, sir. Thank you, Your Honor.
Approaching on Francisco Ochoa.
Okay, let's hear them, Bob.
He's on bond.
Page 24.
So, Judge, the court wanted Mr. Ochoa on docket today, because there was a new case that he was charged with. An assault that happened in the jail. He's currently on bond for tampering. There was allegedly an assault that happened at the jail. Yesterday I came into the court. Richard and I watched the jail video.
Okay.
There's absolutely zero participation from Mr. Ochoa.
this is the stage where things in court can get complicated. Early evidence doesn't always match what comes out later, and it makes you think how many people end up getting pulled into trouble just because they happen to be nearby. This situation might be one of those.
And the fight in the jail, it's all on video. Zero participation. He's clearly in the video sitting down. That's the state. You have to ask the state that one. I have no idea. So Richard's been communicating with the felony prosecutor. He hasn't got a response yet. Currently, there's a warrant out for Mr. Ochoa's arrest.
Well, not a warrant. He's being held at no bond on the assault now, right? He's back there, right?
No,
Where is he now?
there's a warrant out for his arrest. He's in the building right now.
Right. I'm not gonna do anything until I know where he is and we have him, right? If he's out on the lam or just out and about, I'm not doing anything until he's here, you know? If you want me to address it, we do PC, I'm happy to do it, but not till he's here. I'm not gonna, he's gonna be here.
Because if he comes in,
I have he's in jail. I'm showing he's in jail for some reason.
so.
Are you not? It shows jail. Okay, so I'm happy to go through everything with you, but I'm not gonna do it till he's here. You know, really. And if it is what it is, I mean, he's about as reasonable as he
I understand.
is. Show him. Maybe he'll dismiss it
We
now.
just
I
watched
don't
it
know.
again today. We watched it twice. And
He doesn't want to dismiss it?
he wants to communicate with Richard.
Oh, he wants to talk to felony for some reason?
Right. But this is a misdemeanor case where,
Regardless, Mr. Haggard, I never do PC without the defendant being in here to do it, you know, and that just goes with everything. With every single case, I never do PC unless they're here.
Understood.
You know,
All right.
if you want me to do PC, I'm happy to do it, but they gotta be here. And then we'll do it. And then I'm happy to watch any videos that you have as well. We'll watch it all together and we'll make a decision.
like I said.
I'm trying to be as reasonable as I can, you know?
All right, thank you, Judge.
All right, so, good afternoon, Mr. Hodges. So your charge is failure to stop and give information. You have worked out an agreement where they're offering you a 6-month deferred. This is a type of probation that if you complete successfully, you do not end up with a conviction on your record. But you cannot tell people it was dismissed. It does not get dismissed. You merely take a probation, complete it successfully, you don't end up with a conviction. Do you understand?
Sir.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine the accusers, the right to be arraigned, charge read in open court. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this, there's no turning back. Do you understand?
Yes, sir.
Is this what you want to do?
Yes, sir.
Was there no restitution that was due in this? Hey, Blaze,
Yes, sir.
on Mr. Hodges, was there any restitution that was due? It's an FSGI. The agreement that I see so far is a 6-month deferred. No drugs, no alcohol, random testing, and 20 hours of community service.
There's no monetary damages, Your Honor.
No? Okay. Do you understand this?
Yes, sir.
You get this done quick and there's no problems and you're nice to everybody, especially the probation officers, I'll take you off and half the time as a reward.
This is a textbook example of how deferred adjudication is explained. It's essentially probation with clear expectations. The judge is letting him know that if he follows the rules, completes what's required, and avoids any issues, he'll finish the process without a lasting mark. But if he slips even once, there's already a 180-day sentence ready to be enforced. Yes, sir.
Yes, sir.
But if you pick up a new case, you take off, if you do something to violate this agreement, I will issue a warrant for your arrest and you're looking at 180 days in jail.
Sir.
You understand?
Yes, sir.
All right. How do you plead to the offense? Guilty or not guilty? No. It's either guilty or it's not guilty.
Guilty.
All right. I'm not going to find you guilty now. I will withhold that for 6 months, give you the opportunity to complete this. And if you complete it, that's when you don't end up with conviction. If you violate this, though, we put you in jail, bring you out, we'll have a hearing. And if you violate it, like I said, you're looking at 180 days. Do you understand?
Yes, sir.
Okay, good luck to you. Thanks.
Would you like Mr. Ochoa to come up?
Huh?
Would you like Mr. Ochoa to come up?
Not yet. He's here, though, right?
Yes, sir.
So no, I mean, I've watched the video, Your Honor. From what I can see in the video, it appears he's sitting back, I'm being honest with the court.
Just the whole time, there's not participating in the assault. does he provide some kind of assistance, encouragement? Does he say, hey, go get him? Or
So the video,
is it a party type?
honestly, the video doesn't have any audio, so I don't know if he's encouraging them, but it does appear that he's just sitting back on a bench.
So how would they find probable cause?
Unless they did not do their due diligence and put the finger on the wrong guy. Simply, period. It's clear as,
Times, cops will say, hey, look, this guy's a party to it. He was there, and they don't get access to the video to see it. And maybe they just, when they're doing magistration, they don't go through the video to look.
I mean,
That
at the
comes
end of the
later
day,
on.
Judge, without due respect, before you charge somebody with the criminal offense and putting their freedom at stake, they need to make sure that is who they say it is.
I agree with you.
There's a number of people that beat the brakes off of somebody in jail, and Mr. Ochoa had absolutely nothing to do with it, period. He's sitting on a bench from a distance.
But I'm not, you'll find no argument.
And now there's-
No idea.
And now there's an open warrant for him, which definitely would affect this court's case as well as the felony.
Let me look, because sometimes they'll give me information on how someone found probable cause, right?
So, I mean, in the offense, there's an offense report saying that he was stomping and punching repeatedly the complaining witness. And it's clear as day, he didn't.
They got the names wrong. If there was a Francisco Ochoa, there's a Francisco, so there's different Franciscos. Maybe they got it mixed up.
So the cause number is 255-9198. And I have the video queued up if the court would like to see the video.
He's corroborated. I trust Blaze, I trust you guys,
And I'm being transparent on it.
Yeah, that's,
The tension in the courtroom just shot up. Now, there are mix-ups with names, mistaken identities, and a judge trying to understand why someone is being held responsible for a fight they weren't even involved in. It's like watching security footage and seeing the system point the finger at the wrong person. This isn't Theodore Wright's real courtroom confusion.